I hate that lady. All right. I always forget that. Did I have to? Sorry, I'm trying to do too many things at one time. There we go. Sorry about that. All right, welcome to our discussion of your Board of Directors fiduciary duties, a topic that's important because it provides a legal roadmap for your board to govern properly and effectively. This is one of the most difficult topics to cover, to understand, and to apply. So I've done my best to summarize the key points for you. I've included several slides with exact language from the relevant laws so that later you can go back and screen capture any of those slides that you'd like. And I'd like to start with a recap of the management versus governance issue, and then speak to what governance is and how effective governance requires compliance with the law. I think I can't turn off my video. Yes, I can. Hold on. I'm going to turn this off so you can see better. There we go. So, okay, it's not letting me go to the next slide. There we go. Sorry. Who's responsible for managing the day-to-day activities of the nonprofit? Who by law is responsible for management? And here's the surprise, it's actually the board of directors. This is the law in all states. However, management is one of the duties that can be delegated to others. Most often, management is delegated to an executive director or chief executive officer. However, by law, the board may not delegate its duty of oversight of that delegated authority. Once the authority to manage is delegated, though, I'm going to go back one. Once you delegate that authority, it's a best practice to allow the executive director or CEO to manage and the board to step away from that role. In this discussion, we want to discuss then what should happen once the board delegates its management duty. What should the board be doing? They must govern it. Govern. So what is governance? Here it is. It's the exercise of powers and authority granted by law. The two primary functions of governance, and we'll probably come back to this a couple times, are oversight of the administration of the organization and decision-making. The board of directors has a legal obligation to exercise its oversight and decision-making functions to fulfill its mission or public purpose. That's where it's different from a for-profit. For-profit doesn't have to do that, but the nonprofit does. You have to exercise all your fiduciary duties to fulfill the mission or public purpose. And the manner by which you do that is by which you exercise your oversight and decision-making functions is through your legal fiduciary duties. Okay, I hope I made that clear. Sorry about that. I think I'm trying to do too many things at once. Here we go. The American Law Institute has said that volunteer nonprofit boards are often much less knowledgeable about the responsibilities than their paid for-profit counterparts. No board can govern effectively without understanding legal obligations by which they are bound. Just imagine driving a car without knowing the rules of the road. This is especially what is happening when nonprofit boards don't have a clear understanding of the laws by which they are compelled to operate. Good governance practice mandates that all board members must be informed of the legal meaning and obligations of the fiduciary duties. But because of the complexity and extensive body of law developed regarding these duties, there was a need to translate these duties into practices and principles for effective board conduct. Hi, Shakita. Hi, Stephanie. So the need to make all of this more manageable prompted the development of the 10 roles and responsibilities of nonprofit board members that were authored by Richard Ingram in 1988 for BoardSource. But some issues have developed as a result of simply telling boards they can just follow these roles and that'll make them legally compliant. There really can't be a single set of specific actions like a list of roles that will ensure that boards are legally compliant, since different circumstances will inevitably require different actions. Let's take a look at one of the roles to see what I mean. So for those of you who know these, are very familiar with these roles, these will be familiar, but if you don't know them, you can buy them on, let's see, it's on the Board Source website for $29. So I want to look at number 6, because so much of the conflict between leadership, staff, and boards seems to surface when boards are told they have a fundraising role. So number 6 says the boards are supposed to ensure adequate financial resources. If you read the description of number 6 in this little booklet, it goes into great detail about how the board needs to help with fundraising and how boards should contribute funds to the organization. Let's look at this role to ensure adequate resources another way. Many nonprofits operate at a deficit financially. Should the Attorney General of the state step in with a lawsuit suing those boards, imposing liability on them for failing to ensure adequate resources? Let's say, for instance, that the reason for the deficit is that the board made a decision to hire its first paid staff person solely for the purpose of becoming a more effective organization that's more likely to fulfill its mission. Once staff is hired, the nonprofit may experience a deficit for a year or more. If you're seeing a deficit, does that mean that the board is not ensuring adequate resources? And will that result in a violation of the law? Now, I don't want you to come away with the idea the organization should not try to conform to these roles, such as ensuring adequate resources, or that ensuring adequate resources is not a way to comply with the requirements of the law. What I'm saying is that unless your board understands how these roles actually relate to their legal duties, they're not going to appreciate the need to conform their conduct to their legal duties. So what I want to do is help you to understand fiduciary duties. Remember, it is the fiduciary duties imposed by law that describe the manner in which you must govern. Oh, oops, sorry, folks. So here's what a fiduciary is, kind of a simple concept. It's someone acting on behalf of another based on an expectation of trust. And here are the 3 duties: the duty of care, duty of loyalty, and duty of obedience. And technically, relying upon these very old duties described in this common law language is not wrong. But what happens if a board member actually looks up their state's law and finds language different than these 3 duties? For instance, in Texas, our statute on fiduciary duties looks like this. And by the way, you'll see fiduciary duties described as standards of conduct, for instance, or standards for directors. And here in Texas, it says you should discharge your duties, including the duties as a committee member, in good faith, with ordinary care, and in a manner the director reasonably believes to be in the best interest of the corporation. I have New York's law here because Judy's here. All right, here is New York law. Officers shall discharge the duties of their respective positions in good faith and with that degree of diligence, care, and skill which ordinarily prudent men would exercise under similar circumstances in like positions. So why are we seeing this type of language instead of that duty of care, duty of loyalty? Because most states have adopted all or part of the Model Nonprofit Corporation Act. Those model acts are published by the American Bar Association. This one, the Model Code, has been adopted by most all states in this country. And here's where that language came from that we saw in Texas and New York. And it's your standards of conduct, right? Each member should exercise their duties in good faith in a manner that they reasonably believe to be in the best interests. Now, remember I said what governance was? Well, look at B here. The members of the board of directors, when becoming informed in connection with their decision-making function or devoting attention to their oversight function, must discharge their duties with care, okay? And there's your old duty of care requirement. And then in discharging, here's number C, these duties, a director has to disclose to other board or committee members information not already known by them, but known by the director to be material to the discharge of their decision-making or oversight function. And that's the old duty of loyalty, all right? Now, also, I should tell you that all throughout the model code and other states' laws, we know for a fact that the duty of loyalty and the duty of obedience is rolled into the duty of loyalty and duty of care now. The comments to these sections. So in other words, you'll see is a bunch of sections in the Nonprofit Corporation Act. And after each section, the authors, which are lawyers who have drafted all this, have all these comments that they'll explain what they're doing or why they're doing it. And the comments to these sections by the authors, as well as the law in most every state, make clear that we are to understand that the foundation for fiduciary duties still lies in the common law duties of care, loyalty, and obedience. All right, so why does it matter if experts in the nonprofit sector are explaining these duties to us? Well, because there's over 700 years of law interpreting these duties and trying to summarize them without the historical context and some legal guidance means we aren't giving board members the real help they need to conform their conduct to the law. Also, unless we understand the context, when we see these fiduciary duties translated into those famous roles and responsibilities of board members, there isn't an appreciation for those roles and responsibilities in terms of a board member's legal obligations. So even if you give your board a copy of those roles and responsibilities, rarely do we ever talk about them again. And if we do, we aren't talking about them with any appreciation of where they came from or why that context is important if they're truly going to conform their conduct to their legal obligations. All right, now this is part 2. So if you do need to leave early, you'll recognize this slide as the place you want to come back to. And if you're watching it later on YouTube, same thing, you're going to look for this slide. So we're going to traverse the bumpy road of history. And it is what I call part 2. And there's an exercise at the end of this video that will help you align the fiduciary duties to those roles and responsibilities. Now, this next section does include much of the history of the development of a law that today applies to nonprofit boards. I include this because after serving as a board member for nonprofits for nearly 20 years and as an executive director for 8 years, I realized I was not at all sure why we were telling our boards that they do have a fundraising role. So I spent several months researching where this role came from to develop an online course. It was during this little history lesson that I had my aha moment. Once I became aware of how the fiduciary duties developed, I truly began to both understand and appreciate all those duties. Understanding and appreciating fiduciary duties allows our nonprofit boards to govern as effectively as possible. So I want to share a little of what I learned. It is said that we can actually trace the first known mention of fiduciary duties back to Hammurabi's code in 1790 BC, but don't worry, I'm not going back that far. During the Middle Ages, the church was the primary dispenser of charity. In fact, the only legal way to make a charitable gift during those days was by a conveyance to religious corporations. In other words, you gave your gift to a religious corporation and hoped they gave it to the person or persons to whom you wanted it to be given. And that was true basically up until the Norman invasion in 1066 AD. Now, I'm going to take you to a rather astounding period of time after the Norman conquest. This history is filled with mystery, intrigue, and happenstance that could have just as easily resulted in nonprofits never existing. I'm just going to pull out a very few of the most critical and interesting parts of this history. The Franciscans were founded by St. Francis in 1209 AD. The friars could not own property, so they conveyed land to individuals to hold the land for the use of the friar. At the same time this was happening, there were English feudal laws that didn't permit anyone except the legitimate firstborn son to inherit his parents' estate. So the law of uses allowed landowners to circumvent those feudal laws to leave land and funds to other than firstborn sons, like perhaps daughters. All right, the Norman conquest is where we begin establishing a centralized judiciary. This is important because the king got sick and tired of hearing every little complaint, so he assigned cases to officers of the king's court, and they would travel and take the law with them. So it was called the common law because it didn't draw on local laws or customs. It was common to everybody everywhere. Sometime in the 1300s, the chancellors, who were part of the king's system of adjudication, began to be seen as leaders of courts of chancery rather than as representatives of the king. The courts of chancery were the courts of equity and not law. The courts of law were very rigid, but equity courts were always more about what was just. Now today, that's all been combined. Courts have jurisdiction over, they have equity and legal jurisdiction. But it was the courts of chancery that heard disputes related to those uses and started imposing duties on those who were given the use for the benefit of another. Okay, let's skip just a second to right now, today. The law of trusts. You guys hopefully have heard of this. You know, if you've got a minor kid and you want to prepare a last will and testament, right? And you cannot leave. What if you died before that child reached the age of majority? Well, you leave it in a will to a trust. It has to be somebody you trust, right? But there are so many laws related to doing that. Because that fiduciary has to act on behalf of the beneficiary. The beneficiary is the child in this example. And they must hold those assets for the benefit of that child. And they have duties by law that are owed to that beneficiary. And if the trustee mismanages funds, for instance, the beneficiary can sue, bring a lawsuit, right? So how that concept developed into charitable trusts and thus nonprofits is coming up. The history and the law from way back, way back, way before I started this discussion in the Middle Ages, until after the Reformation, is in large part about the struggles between the church and the state. One of the most important fights was between Henry VIII and those who were representing the beneficiaries of those uses. Henry VIII was very mad that most of England, I mean, literally most of England, was held in use because he lost revenue that way. So he found a test case to bring to the courts to invalidate all uses, which, if you can imagine, would have been chaos and would have meant that nonprofits may not have come into existence. He only wanted to allow uses that provided him with a third of their value forever and ever and ever. So the king ultimately won in the courts. That would have been bad. So Parliament passed the Statute of Uses in 1535 and 1536, declaring the validity of all uses and transferring legal title to beneficiaries, which is what eventually gives them those legal advantages. This occurred during the Reformation, which began in 1517. The Reformation was changing the beliefs, values, and culture of the citizens of England. Now donors wanted to do far more than relieve suffering and poverty. The new power elite in England were merchants rather than feudal lords. These newcomers used their wealth to accomplish social change through private funding for charitable institutions like schools, libraries, and hospitals. The charitable trust developed from the history and law of uses. The charitable trust was a legal instrument developed primarily to hold land and endowments and distribute funds and services to the needy. Remember that? For the use of others. The charitable trust made it relatively easy for private funds to be perpetually held for the public purposes, but unfortunately, There were a lot of corrupt officials who abused charitable funds, and the courts were concerned about that. So the law of charity developed strict rules against any personal benefit returning to the trustees and managers of charities, and that's where the conflict of interest stuff that you're so familiar with comes from. This was the, oops, I'm sorry, I went back instead of forward. So this was a historical setting, it's Reformation time, in which Queen Elizabeth I went to Parliament to change the legal infrastructure for charities. The Statute of Elizabeth I in 1601 is the most important legislation in the history of the English law of charity, as in its preamble, Queen Elizabeth I changed the focus of legal purposes of charity from religion, which by the way made a lot of people mad, but she did it. She switched it to social problems, education, employment, and building public facilities. She succeeded in her goal of having private money from the rich religious donors voluntarily directed to funding secular social services and institutions by passing legislation aimed at protecting charitable trusts, not only from abuse by corrupt charity officials, but also from government interference. And if you want to have a whole lot of fun, go look up the preamble to this, the charitable uses, the Statute of Charitable Uses of 1601. The language is a hoot, but you know what else you're going to see in that preamble? You're going to see where our IRS section 501c comes from, because there's a list of what counts as charitable uses. All right, quick jump to America. So the American colonists brought the charitable trust to America, but the development of the business corporation to a position of predominant importance in American business law combined to make inevitable the greater use of the corporate form for all types of charitable activities. You must incorporate to become a tax-exempt nonprofit. But interestingly, if you look up the duties of corporate boards of directors, you're going to see the exact same language about fiduciary duties, because it all originated from the same source. And of course, once our federal income tax was enacted in 1894, we became a dual system of regulation. So back to modern times. So we looked at the private trust concept. The fiduciaries, remember the fiduciary was the trustee for the benefit of the minor child, right? In this context, the fiduciaries are the board of directors who hold the property of the nonprofit for the use of the public, the beneficiary. The legal fiduciary duties, though, are owed to the purposes of the trust, which benefits the public. And of course, the board of directors has the ultimate responsibility and accountability for the organization's actions and assets. Now listen, because there are no identifiable beneficiaries to enforce the rights in the case of charitable trust, who does that? Well, remember, you must incorporate with your state to become a nonprofit. So it's the Attorney General for the state that enforces the rights of the public against nonprofit boards. So now we're ready to look at those fiduciary duties, and we're coming towards the end. But I want to break down each of those three duties so you can understand how they relate to the roles and responsibilities. Remember in the beginning, I told you about Richard Ingram crafting those first roles and responsibilities? Well, I traced him to the Association of Governing Boards of Universities and Colleges, where I believe he wrote or co-wrote their board of directors statement on the fiduciary duties of governing boards. It's my favorite statement I've ever seen. And my thoughts when I read this is that it's meant as a guidance document for boards of directors. So I wanted to share it with you. And if you go looking for it, you'll find a PDF that looks like this. And you know, to be honest, I didn't see his name on this, Richard Ingram, but I hear him in this. And I know he was serving on the board, their board at this time. So I just like this language a lot, where he's saying a fiduciary is someone who has special responsibilities in connection with, you know, the administration, investment, monitoring, distribution of property, in this case, the charitable or public assets. Now check out this sentence. These assets include not just the tangibles, but also intangibles, such as the reputation of the institution and its role in the community. Now, he says, fiduciary principles are at the heart of effective governance, and at first glance to be a matter of common sense. Remember, we were looking at that statute where it said in good faith and within the best interest. He says, well, what could be more essential for a board member than to act with good faith and care, with loyalty to the institution and in compliance with its mission and the law? And yet, behind nearly every failure of governance and leadership at nonprofits is a breach of the principles of fiduciary duty. So let's see how he breaks these down before we end with my exercise. This is the duty of care. And he talks about, there's 3 points he makes, that governing bodies are responsible for both their short and long-term financial health. Now look, you know where he's getting this? Remember I said there's about 700 years of law? That's where he's getting it. And we've compiled a lot of that law and tried to simplify it by putting it into that Model Nonprofit Corporation Act. And because we know all of this, we can say that we're responsible as board members for the short and long-term financial health of the nonprofit. We can say that governing boards have the obligation to develop and protect the quality of the nonprofit's programs and to become appropriately engaged in the oversight. There's that word again. And then there is a little list here of things that he says are required to exercise your duty of care. And this is where we get them again from years and years of law. Regularly attend meetings. So you know what? If you have board members that aren't attending their meetings regularly, they're breaching their fiduciary duty, folks. So you need to give that some thought. They need to read and evaluate the meeting materials. They need to ask questions, participate actively in board discussions, be knowledgeable of the institution's purposes, operations, and environment. All right, then we come to the duty of loyalty. Basically, this is, you can't serve two masters. The duty of loyalty considers a board member's financial interests and the governance or leadership positions he holds elsewhere. And the most critical implementation of the duty of loyalty comes in the nonprofit's conflict of interest policy. You must be loyal to your nonprofit mission and governance documents. And then the duty of obedience, which is believed now and stated in that Model Act to be rolled into the duty of care and duty of loyalty. The duty of obedience means the nonprofit is operating in furtherance of its stated purposes and is in compliance with the law. It says that you're making reasonable efforts to ensure that your nonprofit is both legally and ethically compliant with the law and applicable internal and external rules, and that you've instituted effective internal controls to achieve that compliance and to identify and address problems. All right, so here comes my exercise. I'm going to leave you with this exercise. On my website, if you go to poweryourmission.com, go to the free stuff tab and scroll down to, I think it's under the board orientation packet. You're going to find my roles and responsibilities, which are very different from any of the others you're going to see. There's 2 reasons for that. Well, one is I've reduced them to 7 because I think I can do that. And the other is I have a preamble related to the fiduciary duties, lest we forget. It's just not a matter of looking at those roles and trying to implement those. It's that you have to be in compliance with the fiduciary duties. Okay, so here's the exercise. I want you to go download those, look at each of the roles and try to decide which of those 3 duties apply to which role. Then, if you can figure out which duty applies to which role, have one board member of each board member describe one duty and which role it applies to, and how that role helps your board to comply with that duty. That's what I meant to say. Okay, so they want to describe the duty and which role helps your board to comply with that duty. Maybe the board member with the role can even add how it's meaningful to them. This will keep the importance of their governance roles at the forefront of the board service. It could take 5 or 10 minutes only at board meetings. I highly recommend that. Now, if you need some help with the exercise, you can always call me. Set up a call. It's called a strategy call. It doesn't matter what it's called. You go to my website to the contact us page and book an appointment. I'll help you work through that exercise to show you which duty applies to which role. All right. All right, that brings us to the end. That was longer than normal, and I'm very happy to see that you guys hung in there. I'm very impressed. Listen, I'm going to be closed in December. That means there's not going to be any meetup. There's no interviews. But during that time, I'm going to be preparing for the change that's happening in January. We're changing the name from Austin Nonprofit Meetup to Nonprofit Leaders Meetup to reflect our nationwide membership now. And if you need to reach me, you can do so on my website or at nancy@poweryourmission.com. And then one other point I wanted to make is on my YouTube channel. I'm just learning this because I'm not that great with YouTube, in spite of the fact that I have a lot of videos up there. There's playlists. I have 6 of them, and I might build out some more, and I might change this up. But there's something I learned. If you hit on playlists, you'll see that there's 6 playlists. And under each one, like the one that this video will now be under, it's called Nonprofit Board of Directors. It'll say the title, but you have to click on view playlist under each title to actually see what's in there. That seems silly to me, but there you have it. All right, guys, I want to thank you so much for hanging in there. I can't really believe you did that. I really appreciate that. And I'm going to go ahead and say goodbye and wish you happy holidays. Thank you so very much.